Appeal in the matter of the Queen on the application of DK and the Commissioners for Majesty's Revenue and Customs and another.
Yes, Miss Ward.
Good morning, my lords, my lady. My lord, a sort of quizzical glance. I wonder if there's something you'd like me to deal with first.
No, I've haven't got to the stage of being critical yet.
I'm sure it's only a matter of time. My lords, my lady, as you're aware, I represent the appellant or appellants, Her Majesty's Commissioners for Revenue and Customs, and the interested party, the Secretary of State for Work and Pensions, whose transitional provisions it is that fall to be interpreted on this appeal. My learned friends, Mr. Cox and Mr. Spencer, appear for the respondent, who was the claimant below, Mr. DK. And the question on the appeal is whether a person in Mr. DK's position, who was recognised as a refugee and therefore became able to claim what might be termed mainstream social security benefits after the transition from legacy benefits, including child tax credits, to the new system of universal credit, whether a person in that position is able to make a claim for tax credits to which he would have been entitled had he been recognised as a refugee, and so able to make his claim for them at an earlier time.
Yes.
My lords, a few preliminary matters. First of all, housekeeping, because there are a number of bundles and things flying around.
Yes.
There is, and I understand from your clerk that the court has the core bundle, the agreed supplementary bundle.
Yes.
An unagreed supplementary bundle containing a single witness statement from an official in the Department of Work and Pensions. And my lord, I'll come on to the substance of that in a moment, but just for now, does the court have both sets of submissions addressing that unagreed bundle? So I think 2 pages for me when it was submitted and 3 pages for my learned friend.
Yes.
In response.
Well, shall we deal with that now? Our view, of course, we've looked at the witness statement. Oddly enough, if anybody thought we should look at the exhibits, we haven't got the exhibits, but we've looked at the witness statement. Speaking for myself, it seems to me, insofar as it sets out the history, it's admissible and helpful up to a point, insofar as it tries to say that what the draftsman of this or that regulation had in mind was X. It's not admissible.
Well, broadly, that's my position.
Yes.
It's there, it would be artificial in my submission to exclude it entirely.
Yes.
It having been prepared, of course, largely in response to the no longer live human rights grant, so it does to some extent deal with what the government was trying to do and why, and I accept that that's not the issue before you, but in terms of setting this provision in the wider statutory context, that's what it was relied on for in part below, and that's what I'd ask you to, not even sure that I will take you to any particular part of it, but it seems to me that it's entirely possible the court may have questions about the context that are answered within it.
Yes. Well, I think formally, subject to anything Mr. Cox may say, formally our decision would be that we look at it for the moment de bene esse, and we formally rule on its admissibility in the course of our judgment. But I think that the general approach is what I set out earlier. Mr. Cox, are you content with that?
My lord, there are certainly passages in the statement that are neutral descriptions of the legislative history, and as we set out in our submissions, we would have had no objection to an application to admit only those. In my submission, it would have been preferable if the application had been limited to those paragraphs.
It would, but we're grown-up people, and we can work out for ourselves which bits of the statement go beyond what is admissible evidence, I think.
My Lord, yes.
All right. Thank you.
I'm very grateful, my Lord. I'm grateful to my learned friend as well. My Lord, turning then to the authorities bundles, there's a main bundle in 2 volumes,
Yes.
largely legislative provisions, but a few authorities at the end.
Yes.
And then a further short supplementary bundle of authorities, which I understand has been handed up this morning.
Yes.
It was sent in yesterday as well. That is produced because the judgment in Adnan,
Yes.
which obviously is featured quite largely in both of our submissions to you, was handed down by the Inner House last week
Yes.
on Tuesday, and so we've both responded to that.
Normally, we would be quite cross at a supplemental bundle being handed in at the last moment, but in the circumstances of this case with the Inner House decision last week, it's understandable.
I'm very grateful, my Lord. And then finally, you should have a short supplementary skeleton from each of us
Yes.
addressing that decision of the Inner House.
We do.
So,
Well, let's come to that, Ms. Ward. Do you accept that the comity principle set out in Abbott and Philbin and Secretary of State for Work and Pensions and Dean means that it's really not open to us to come to a different decision from the Inner House?
well, I appreciate it's an ambitious submission, and what I suppose I'm really hoping this court will do is express its own views for the benefit of the Supreme Court, to whom an application is to be made to appeal against the judgment of the Inner House.
Yes.
And I
Well, I
appreciate
understand,
this
I
court to go
understand
further
that.
is ambitious.
But are you saying that we should say we think the Inner House is wrong and we therefore allow the appeal, or are you saying we are bound by the comity principle to follow the decision of the Inner House and thus dismiss the appeal, but we're very unhappy about it for the following reasons? Is that what you're trying to get us to say?
My Lords, I don't formally concede my appeal, so I'm not saying to this court that you must dismiss it. And what I say about that is that in the really quite unusual circumstances where these 2 cases have proceeded in parallel, if you are convinced by my submissions that HMRC's position is correct, then the matter really ought to proceed to the Supreme Court, because the alternative is a wrong decision in circumstances where there is an appeal, an application for permission to appeal already on foot in Scotland. And in those circumstances, the court may feel that the comity principle has less force, because there is a need for the matter to be resolved at Supreme Court level in any event.
But the comity principle surely has enormous force, I mean, particularly at appeal level. If we allowed the appeal, then it would be really holding a gun to the head of the Supreme Court, saying, unless you take both these cases, the position will be that there is binding authority in England and Wales that the law is X, and binding authority in Scotland that the law is Y, on identical points.
Well, I do see the force in putting it that way round as well. But as I said, I don't formally concede that you must dismiss the appeal, but
No.
realistically, I accept that the best I can probably hope for, if you're with me, is a strong expression of that view.
All right, let's get underway then.
I'm grateful. Well, my Lords, we've already dealt with the fact that I'm effectively 5-0 down in terms of the findings in this case already, albeit that Mr Justice Bourne did recognise the force of HMRC's position, but felt constrained to follow the decision of the Outer House in Adnan, whilst granting my client's permission to appeal to this court. My Lords, what I propose to do is really to follow the form of my written submissions. Firstly, to set out my client's case under the statutory scheme and explain the provisions that get us here. And then to what I say is on the face of it, the straightforward effect of the transitional provisions, and then address the arguments to the contrary, including those, of course, those made by my learned friends, but also those that found favour with the courts in Scotland in Adnan. And there's, of course, some overlap, but also some differences between those two sets of arguments. Unless my lady indicate to the contrary, I wasn't proposing to address you on the facts. I mean, the facts are entirely uncontroversial. It's the key fact, as I've already indicated, is that Mr DK was recognised as a refugee at a time when universal credit, under the provisions that I'll come on to describe, had been rolled out in his area, and it's accepted that in those circumstances he was only able to, and indeed did, make a claim for universal credit as a current ongoing payment, social security payment to him. Well, this case arises out of the previous statutory scheme in relation to tax credits, and I've set that out from paragraph 4 onwards of my skeleton argument, which is in the core bundle. This paragraph begins at page 16. And I've dealt there, first of all, with the main statutory provisions underlying the system of child tax credit, tax credits more generally, in the Tax Credits Act 2002, which is in tab 2 of the main bundle of authorities. As I say there in paragraph 4, the starting point is section 3 of the 2002 Act, which is on page 8 behind tab 2 in the authorities bundle. And that's a provision that is relatively common in substance, if not in precise wording, in the system of social security, which is that entitlement to a tax credit for the whole or part of a year is dependent on the making of a claim for it. So entitlement depends on claim, and making a claim, therefore, is key to the system of tax credits. Section 4, then, over the page, provides that regulations may make provision about various matters, but for our purposes, 4.1a and b, about claims, requiring a claim for a tax credit to be made in a prescribed manner and within a prescribed time, or providing for a claim for a tax credit to be made, or to be treated as having been made at an earlier date. So that's the key provision that underlies the regulations, the claims and notifications regulations, to which I will take the court in a moment, about the making of claims. But just whilst the 2002 Act is open, could I ask the court to look at section 14, first of all, which is on page 23. That's the main decision-making provision, if you like, that on a claim for a tax credit, the board, which is because HMRC must decide whether to make an award, and if so, the rate at which to award it. So it's the making of a claim which then requires that claim to be determined under Section 14. Tax credit was a slightly unusual form of benefit in that the award was made for a year and then annualised and then paid in instalments. And of course, matters could change during the year. And there are provisions in Section 16 for what happens if there's a change of circumstances. It's also the case that formally a fresh claim would be required for a new year's worth of tax credits. The court will recall that Section 3 provided that entitlement for tax credit for a year or part of a year depended on a claim being made for it. Once a claim was in payment, once a person had made a claim and been accepted as being entitled to tax credits, then the system depended on the provision in Section 17, which is on page 26 of that tab, where a notice was sent each year to a tax credit claimant or a tax credit claimant couple. They were then required to fill in relation to their current circumstances. And if my lord, my lady, then turn to tab 5 in the bundle of authorities. That's where you'll find the claims and notifications regulations made under Section 4. And the key relevant regulations for present purposes are firstly Regulation 5 at page 111. Which provided for the manner in which claims were to be made in writing on a form approved or authorised by the board, or in such other manner as the board may decide, having regard to all the circumstances. But in the circumstances where a Section 17 notice had been completed, at Regulation 11, beginning on page 117, one sees the provision that the person who's filled in such a notice is treated as having made a claim for the next year. So that's how the system would ordinarily operate. A person makes a claim complying with Regulation 5, and the decision is made under, first of all, Section 14 as to entitlement. And then, if there is entitlement and if payment is being made, a Section 17 notice will be sent out, be completed each year, and a fresh Section 14 decision will be made for the next year. So it can be awarded on an ongoing basis in that way without the need for a new claim to be submitted under Regulation 5. There are some provisions in the 2002 regulations that provide for a claim to be treated as having been made slightly earlier than it actually reaches HMRC, and that's principally, certainly in relation to child tax credit, Regulation 7, which is on page 113. And the net effect of that is that if a person becomes entitled to tax credit, they have 31 days to make a claim, and at which point it will cover the entire period for which they've met the conditions of entitlement. If they leave it for more than 31 days, they won't be able to backdate it any further than that. So those are the straightforward provisions. Insofar as anything in relation to tax credits is straightforward under the 2002 Act and regulations. There are then the 2003 regulations, which are made under Section 42 of the 2002 Act. And if I could just ask the court to look at that provision, it's on page 72, and behind tab 2 in the main authorities bundle. So Section 42 permitted regulations to make provision in relation to persons subject to immigration control. That's defined by Section 42.2 in Section 115 of the 1999 Act, and it's common ground that an asylum seeker, a person who was in Mr. DK's position prior to being granted asylum, was a person subject to immigration control. In relation to persons subject to immigration control, Section 42 permitted the making of regulations for excluding entitlement to either the whole or prescribed element of tax credits, or for the other provisions of Part 1 of the 2002 Act to apply subject to other prescribed modifications. So it could either exclude entitlement in whole or in part, or modify the way in which the other provisions apply. And the regulations, as I say, made under that section are the 2003 regulations, which are at tab 4 of the bundle of authorities, beginning at page 97. And the operative provision, Regulation 3, begins on page 98. And the general position under Regulation 3.1 is a total exclusion for the purposes as envisaged by Section 42.1. No person is entitled to child tax credit or working tax credit while he is a person subject to immigration control, except in the following cases and subject to paragraphs 2 to 9. Now, pausing just for a moment on those cases in Regulation 3.1, because this is in part relevant to something that was said by the Inner House in Adnan. Those cases are various classes of person who, although subject to immigration control, are entitled to child tax credit or working tax credit. And one of those, the last one, case 5, deals with effectively third country nationals who had the benefit of agreements between the EU and their country of origin. And amendments have been made to that case post-EU exit to reflect obviously the slightly changed legal position, to make that terminology correct in terms of who those people are. They may, of course, be people with ongoing tax credit claims that would, although new claims to tax credits under the provisions that I'll show you can't be made, are treated nonetheless as being able to make a claim each year for the ongoing payment of tax credit if they've not been migrated into the universal credit system. Turning to the provisions directly relevant in this case, those begin on page 100. Regulation 3.4 is, in substance perhaps, other than the closing words, an avoidance of doubt provision, where a person has submitted a claim for asylum as a refugee and in consequence as a person subject to immigration control. In the first instance, he's not entitled to tax credits, but then that's subject to paragraphs 5 to 9 below. And paragraph 5 provides that if that person is notified that he's been recorded as a refugee, so granted asylum in common parlance, and claims tax credits within 1 month of receiving that notification, then paragraph 6 to 9 and regulation 4 shall apply to him. And the net effect of paragraph 6 to 9 is that that person is treated as having claimed tax credits for each year or part of a year between the date of their asylum claim and the date on which they're recognised as a refugee, and then their entitlement will be calculated accordingly for that period, subject to the provision in paragraph 9 setting off payments received under the asylum support schemes. And the simple submission, I think I've flagged quite clearly both in my written submissions and this morning. The simple submission there is that paragraph 3.5, regulation 3.5, requires tax credit to be claimed within 1 month of receiving that notification as a refugee. So the regulations in relation to what is a claim for the purposes of section 4, which is, although there are modifications of some of the other provisions of the 2002 Act under regulation 4, there's no modification of section 4 or the regulations made under it. And so the requirement to make a claim in the same way so as to generate the obligation to make a decision under section 14 is the same for a person who's just been granted asylum, recognised as a refugee, as it is for any other person seeking to claim tax credits. And regulation 3.7 specifically provides that the backdating provisions under the 2002 regulations won't apply for these purposes, so you don't get the month and then the further 31 days. But otherwise, those provisions in relation to claims are left undisturbed. So, again, the ordinary case would be that a person is recognised as a refugee, makes a claim within 1 month of the grant of refugee status, and then is treated as having claimed in each year or part of year, intervening between the date of the asylum claim, which has just been successful, and the date on which their status as a refugee was recognised. So that was how it worked under the tax credit system. And then, as is, I'm not sure I even need to rely on the witness statement for these purposes, as is relatively well known, a new system of universal credit was introduced under the Welfare Reform Act 2012. That's at tab 3 of the bundle of authorities.
Sorry, just before we leave page 100, do you accept that the provisions you've just been showing us have never been repealed?
They've not been repealed, no.
So they remain part of the law of this country as we speak?
Yes, as do the claims and notifications regulations. Yes.
And I hope it's not parodying your case, but your central point is if these regulations stood as they were and there were no subsequent regulations, Mr. DK would clearly have been able to make a valid claim for tax credit within a month of his refugee status. But, you say, subsequent regulations say you can't claim tax credit anymore, So that is a barrier to 3.5 being any use.
Yes. It really is almost that straightforward. And Melody, that brings us then to those provisions. All I wanted
Going back to my Lord's question, I mean, if that's right, why haven't these regulations been repealed?
Well, my Lord, as I hope I already showed you, part of Regulation 3 relates to, or may relate to, ongoing claims. Well, there is an explanation, in fact, in Mr. Naeem's witness statement about the difference between natural and managed migration in this context. So, although the scheme is shut to new claims, persons with existing tax credit claims are treated as making a new claim for each ongoing year, and therefore that first part of Regulation 3.1 remains relevant to them.
So there's still people out there who are qualifying for the legacy benefit because universal credit hasn't yet been fully rolled out.
My lady, yes, and I can give you a
Right.
reference for that. In Mr. Naeem's statement, it's on page 5 of the statement. Perhaps the beginning of paragraph 25, Mr. Naeem up to that point has explained the scale of the undertaking and that it can't simply be done by turning off tax credits and turning on universal credits. And he says that it was decided that it could only be successfully achieved by allowing access to universal credit only for those needing to make a new claim, so fresh claimants, and existing claimants whose circumstances changed. And he says at the end of that paragraph, in due course, the remaining population of those on legacy benefits who have not had cause to make a new benefit claim and thereby naturally migrate to UC will be administratively moved onto UC by managed migration, and then legacy benefits will cease to operate. But as he explains at paragraph 27, a pilot for managed migration started in July 2019, but was suspended during the pandemic. And the court may recall, in fact, there was some publicity, to use a neutral word, around the fact that the increase in universal credit didn't apply to those who were, during the pandemic, didn't apply to those who are still on legacy benefits. They are still a real cohort of people.
So the 2003 immigration regulations, some of them still have some effect, although 3.5 doesn't.
Yes, effectively. So it became redundant at the point where, realistically, no one who was a refugee, or no one who was granted refugee status, would then be able to make a claim for child tax credits. And that was a point that is not easy to pin down with absolute certainty, and it's again a point that's covered in Mr. Naeem's statement, because there are particular savings. The entirety of the 2002 Act is still technically saved, save where the ability to make a claim is blocked, and that's partly because of the need to preserve it for, there were some decisions about people entitled to severely disabled premium and how the transitional provisions affected them, and they had to be migrated back effectively to tax credits. And there was also a period during which the universal credit system apparently couldn't accommodate the two-child rule. And that's one of the footnotes to Mr. Naeem's statement. And so new claims had to be permitted by those with more than 2 children under child tax credits. So there are these various sort of moving parts. And I don't wish to supplement the evidence, but there's never come a point at which the government has decided, well, we'll just get rid of this now. It's just been left. But realistically, the position is that it's vanishingly unlikely to the point of, as I understand it, impossible to imagine a person who would, within a month of being granted refugee status, be in a position to claim child tax credits, because simply the remaining very, very narrow exemptions are unlikely to apply to them. So, my Lords, my Lady, I've dealt with, to some extent, the complexity of the process of rolling out, and that is described in Mr. Naeem's statement. That's really what it was relied upon for at first instance. The way in which it was brought into force, postcode by postcode, ultimately. So, postcode by postcode, the whole of the United Kingdom became a full service area for universal credit. And from that point onwards, new claims to tax credits were not permitted, and claimants had to claim, as Mr. DK did, universal credit. I've described the precise mechanism by which that happened in my skeleton argument from paragraph 15 through to 21 on page 19. The net result of those provisions is, as I've described it, that areas became full service areas, and from that point on, new claimants could only claim universal credit. And as I say, at paragraph 22 on page 20, it's common ground that that was the position for Mr. DK when he was granted refugee status. So unless the court feels it would be of assistance, I don't propose to trawl through that sort of jigsaw puzzle of how we get to that position, because it is accepted to be the position. And indeed, the court will see from Mr. DK's own evidence that he made a claim for universal credit. One comes then to Article 7 of the relevant order, described in my skeleton argument as the number 23 order. And that's tab 8 in the main bundle of authorities. And Article 7 is at page 283. It begins at page 283. I've also set it out in my skeleton argument at paragraph 23, the main relevant parts underlined, and the main operative provision, the part that my clients understand to prevent any claim for tax credits by a person in Mr. DK's position, is Article 7.1. Which provides, except as provided by paragraphs 2 to 6, and none of paragraphs 2 to 6 have any application in this case. A person may not make a claim for housing benefit, income support, or a tax credit on any date, where if that person made a claim for universal credit on that date, the provisions of the Act listed in Schedule 2 to a previous Commencement and Transitory Provisions order would come into force. In relation to that claim for universal credit. And it is common ground that that is the position that Mr. DK was in, that those closing words of Article 7.1 apply to him. And the debate in this case is not about those words, but about the first words that are underlined: a person may not make a claim for housing benefit, income support, or a tax credit. So my straightforward position, as I quite fairly characterised it, and as I put it at paragraph 24, skeleton argument, is that Mr. DK was not able to make a claim for child tax credit on that day, and that included a claim. Because he couldn't make a claim, there was nothing for Regulation 3 of the 2003 regulations to operate on. The argument to the contrary is based primarily on the second part that I've underlined in paragraph 23 of my skeleton argument, which relates to the definition, or what's said about a claim for the purposes of this article, and that's that a claim is made by a person on the date on which he or she takes any action which results in a decision on the claim being required under the relevant regulations. And the relevant regulations are defined in subparagraph 11G, and they include the Claims and Notification Regulations, 2002 regulations, which contain, made under section 4, which contain regulation 5 that I've shown the court, but there's no reference to the 2003 regulations.
I found this subparagraph difficult to follow. The date on which he or she takes any action, is that the making of the claim? Why not say so? Anyway, right. He or she takes any action which results in a decision on a claim being required under the relevant regulation. Yeah. I mean,
It becomes a circular argument, doesn't
Yeah.
it? Because whether a decision is required depends on whether or not a claim has been made, and whether a claim can be made depends on the first part of the sentence.
I share my lady's pain. I have done in the past, but having spent a considerable amount of time with these provisions, maybe the purpose of these provisions in my submission is to identify the date on which the claim is made. So a person may not make a claim on any date. Question, has a claim been made on that date? And what subparagraph 8 is then saying is that the claim is made on the date on which action is taken, which results in a decision on the claim being required. And we know from section 14 of the 2002 Act that a decision is required if a claim is made. And the provisions in relation to how to make a claim are in the 2002 regulations.
That's when the form is filled in and sent to the revenue.
And they're only in the 2002 regulations. So it's section 4 that provides the power to make regulations in relation to how a claim must be made. Those are therefore the relevant regulations when one is looking at what action is required to make a claim and therefore require a decision.
2003 regs have no such provision.
No. And section 42 does, well, section 42 enables other parts of the 2002 Act to be modified for those purposes, but there is no modification of section 4 or the 2002 regulations, save that, as with Article 7, the provisions in the 2002 regulations which backdate, as I described, the 31 days to make a claim. Those are also excluded, as I explained, under the 2003 regulation. So the extra 31 days isn't there. So what's the effect of subparagraph 8 for tax credits purposes, because the only relevant regulations for tax credit purposes are the Claims and Notifications Regulations 2002, is that the key date is the date on which action is taken. The claim is received by HMRC in the required format, and it's irrelevant that the effect of any other provision of those regulations would deem that claim to have been made earlier. So the date on which the focus of this regulation is brought is the date on which the action is taken.
But does 8b apply at all? I mean, Mr. Cox doesn't rely on any provision of the relevant regulations. He relies on 3.5 of the 2003 regulation.
Yes, Word 8b doesn't apply here. I think, as I understand Mr. Cox's point, it's that 8b makes effectively regulations 7, 7a and 8 of the 2002 regulations irrelevant, but doesn't make any such provision in relation to the 2003 regulations. And I say, well, the 2003 regulations are premised on a claim being made, which must have complied with Regulation 5, because that's the only provision that deals with claims being made, how claims are to be made. And it's the date on which the action was taken that constitutes the claim, as defined in those regulations under Section 4 of the 2002 Act, that is being identified here as the relevant date for the purposes of Article 7.1. My Lord, my Lady, effectively, my submission there is that the 2002 regulations are the regulations under which a claim is made, and those are therefore the gateway to the relevant provisions of the 2003 regulations having any application. If there is no claim, then Regulation 3.5 doesn't apply, then Regulation 3.6 doesn't apply either.
So it's only once you've got a claim which is made in the prescribed form in the 2002 regulations, that claim in existence is then deemed by the 2003 regulations to have been made on an earlier date.
My Lady, yes, subject to this qualification that because of the slightly odd system with tax credits of the annual claims, if this was a mainstream, a Department for Work and Pensions benefit, then that would be exactly the point. It would be just backdated to the date of the asylum claim, and the entire period would be filled in, and that was the previous system that was abolished in 2007, and there's some discussion of that in the human rights section of Mr. Justice Bourne's judgment, which obviously neither of us put on the required reading list. So tax credits is slightly different because of the necessity for a fresh claim every year. Rather than the claim under Regulation 5 being deemed to have been made back when the asylum claim is made, the person is treated as having made a claim on that date for the relevant tax year, and as having made a claim
So there's a notional
for each
claim,
next year.
which is then repeated, notionally repeated.
But the Regulation 5 claim operates in the normal way for the current tax year.
If one approaches it from the point of view of what is the underlying social purpose of that deeming provision, could it be said that that is the benevolent provision, which it could simply have said that your entitlement isn't backdated, or isn't backdated to the date of the original claim for asylum and each intervening tax year. But the will of the legislator was arguably a benevolent one, that it is deemed, and therefore could it be said that that is in some way some kind of existing legal right, and that if that's to be cut down, then it can only be done by clear words. I may be mistaken, but I think that's part of the reasoning of the Inner House.
My Lord, yes, and I was going to deal with it at that point. But now,
yes,
now it's convenient.
Please come back to it at the right time.
But, well, just in terms of the intention of the legislator, there is an account in Mr. Naeem's statement of the fact that until 2007, this was the position for all benefits. It was then changed in 2007 when the system of refugee integration loans was introduced, and there's some discussion or some account of the debates that explained that. And at that time, as Mr. Naeem explains, the amount of child tax credit was equivalent to the amount of asylum support that was being paid for children under the 1999 Act. And that was noted. I can't say that it was, I'm not making the submission that it was, that this court can or should proceed on the basis that that was why it wasn't moved in tax credits, but it was noted, and no change was made to tax credits, which of course was something of an outlier in the welfare system because Social Security generally was administered by Department for Work and Pensions. So the legislative intent is perhaps not as obvious as it might appear, fully accept it might appear at first blush that this is a particularly a more generous provision. Effectively, exactly as my lady described, tax credits was a system in which there was this backdating. And although it's formally a repeat claim over the years, the net effect is the same as under the previous DWP benefits, that the claim is backdated to the date of the asylum claim. Universal credit does not contain that provision. So the switch from tax credits to universal credit, whilst may potentially containing some advantages for new claimants to universal credit, also was in some ways less generous, and one of the ways in which it's less generous is that the backdating doesn't exist. So the straightforward position of my clients is that if you can claim universal credit, it doesn't have backdating. If you could have claimed tax credits, it would have had backdating. It's a switch from the system, and that is express on the face of the legislation, because the legislation provides that when universal credit comes into force, tax credits will be abolished.
Is that in primary legislation?
My Lord, yes, and I see that I skipped over that section that I was going to show you, my Lords, in the 2012 Act. It's my fault. That's at tab 3 of the main bundle of authorities. So the court has there at page 80, first of all, section 1 of the 2012 Act, introducing a benefit known as universal credit. So that's the new benefit. And at section 33 on page 90.
Yes.
It's provided that the following benefits are abolished, and that includes 33(1)(f), child tax credit and working tax credit. That, of course, is the end state. Only universal credit will exist. Child tax credit will be abolished. As has already been discussed, we're not at the end state yet. There are still continuing tax credit claims in payment. And section 150 on page 95 is the commencement provision. Effectively gives dates for certain provisions in the 2012 Act to come into force, but not a fixed date for section 33. So section 33 is subject to section 150, subsection 3 will come into force on such day. Secretary of State made by order, made by statutory instrument appoint. The number 23 order, which we've been looking at, Article 7, is one of those orders. And as section 154 provides, that may appoint different days for different purposes, different days for different areas, etc.
All the usual stuff.
So, ultimately, the debate really is between whether, when it comes into force, that's a clean switch, universal credits apply, tax credits don't, or whether the fact that, because as has been described, the architecture of tax credits under the 2002 Act has not yet been abolished because of the ongoing claims and indeed the need for preserving the possibility of new claims in certain circumstances.
I know that's your case, and it may be right, but whether it's right or not depends on the correct interpretation of the relevant legislation. Another way of looking at it, possibly, is that what was happening, as UC is rolled out, and the new legislation starts to come into force through various commencement orders, one way of looking at it may be that there is a risk that it's going to interfere with people's existing vested rights, precisely because the existing legislation had the backdating provision. So if you simply say, well, you can't make a claim for tax credit any longer because we've said so, well, yes, you've said so, but the citizen may say, well, hang on, there's other legislation which hasn't been repealed, which says that although I didn't make the claim until X date, it's deemed to have been made many years earlier, and so I've got these vested rights. You can't just take those away from me unless you use very clear words.
Well, firstly, I come back to the starting point, which is that there is no entitlement in this situation without a claim. So,
No, I understand that.
And that is a point of some importance in the overall structure of the system. Secondly, my submission will be, and I'll come on to develop it, that a claim that has not been made cannot therefore be a vested entitlement. It's a possibility of making a claim at some stage if conditions were different, but the legislature is entitled to change the rules effectively on what claims can be made, what entitlements exist.
Well, you say that the right doesn't vest until the grant of refugee status or the making of the claim a month later, and whichever it is, it's too late.
Yes.
I understand the point, obviously, but I'm just wondering whether a possible other way of looking at the situation, as a matter of substance, as opposed to form, is that the reason why there was the deeming provision in the first place was that it was a recognition that you'd always been a refugee.
Yes.
Although it took many years, as we know it does, and that's not a criticism, that's just a fact of life. But could it be said that the purpose of the 2003 regulations, particularly Regulation 3.6, was that it's the fact that your status is recognised later shouldn't prejudice the fact that actually you've always been a refugee, and therefore, as a matter of substance, you were entitled to this benefit.
Well, it's that, I think, it's really just those last words
Yes.
where the issue crystallises. That is, and as my Lord has described, must have been the underpinning for all of the previous provisions in all of the benefits that provided for backdating to date of refugee status. And there was, as was at issue when my learned friend was running an Article 14 discrimination point, there was a conscious decision to not have that in universal credit. So that will not be the case, is intended not to be the case, where the only claims that can be made are claims to universal credit. So in substance,
there's no cross appeal against the Article 14. Yeah.
well, in substance, on the face of primary legislation, that is a change that is happening. And my submission is that the express words that you are effectively, you are now a universal credit claimant, not a tax credit claimant, is absolutely clear to have that effect, that you are now not entitled to backdating because you're in the new system.
Well, that doesn't really answer the suggestion that my Lord was putting to you, that actually because the quote grant of refugee status is the state saying in effect, we accept that you have been a refugee ever since you came here.
Well, this may be a bit of a side issue, but that's not necessarily the case here, in that it was I think, fourth asylum claim that was successful. So, but in any event, it's accepted that Mr. DK has, in any view, been a refugee since that last claim was made that was successful.
All right, since the making of the last. Well, is that right? If you, the fact that you have to claim several times doesn't alter the fact that.
Well, it may do. There are different possibilities.
Absence and
there may be a
more
change of
exotic
circumstances.
facts, but.
My Lord, there will, for example, be a number of people now in the country who, from say Afghanistan, who are
Yes.
now entitled to refugee status.
No, I see that, but this is not such. This is not such a case.
Well, there's no evidence about the factual background before you, and that particular issue hasn't been determined. You may see a reference in Mr. DK's statement to HMRC in relation to his child benefit claim, taking the position that it was the date of his most recent asylum claim that was operative, and he was appealing that. I'm not actually sure what happened on that appeal. It's not an issue. Well, it's not an issue that this court has to determine, and for the point of principle, it's absolutely accepted that recognition as a refugee connotes recognition that a person doesn't become a refugee on that day. It's a state of affairs that has existed, at least whilst the claim's been being made.
Yeah, whether it's from day one, when he first arrived in the UK, or whether it's the day on which he made the claim for made the claim for asylum, doesn't affect I think the issue that we're currently having to grapple with in this appeal, and you accept, as I understand it, that the grant of refugee status it's not you are a refugee from now. It is that you were a refugee from the date when you made the claim for asylum, which we are now accepting. Yeah. Now, could it be said, therefore, that leave aside the legislative form? You may say you can't leave aside the legislative form because that's crucial. I understand your case, but I'm just trying to see it from another perspective, which is substance, and from the point of view of the individual and the real life impact on them and their families. And could it be said that from that perspective, the state is recognising that although you were not recognised officially as being a refugee until a much later date, in fact you were a refugee throughout the relevant period. And throughout the relevant period, you could have claimed tax credit. If this had been known earlier, you would have been entitled to tax credit. So in that sense, could it be said that the purpose of the 2003 regulations was, as I suggested earlier, a benevolent one? And if that's to be interfered with by the introduction of and the rollout of UC, could it be said that that does require something very clearly taking away what on the face of it looks like a previous entitlement?
My Lord, I say that's supplied by the primary legislation,
Yes.
firstly, which says abolished.
Yes.
And then the requirement to be able to make a claim.
Yes, I understand.
My Lord, absolutely, I accept benevolent purpose, but there is, as I've said, a passage in Mr. Naeem's statement that addresses the history of this. I just want to make sure it's not a passage that might be controversial. My Lords, it's on page 9 of the witness statement.
Paragraph.
Beginning at paragraph 42, it's the backdated, the history of backdated
Oh, yes.
defendants and new refugees.
My Lord, I apologise for interrupting, but paragraphs 42 and 43 are not in dispute. Paragraph 44 is. Paragraph 45, the second sentence is. The remainder of those paragraphs.
Just go through that again. 42 okay.
42,
43 okay.
44 not accepted. 45 second sentence not accepted as admissible.
So 45 second sentence.
Yes.
Yes. During debate in the House of Lords.
Yeah.
Yes.
My Lord, if we're going over the page, the last sentence of 46, not accepted.
Yes. Right.
My Lords, I say I'm referred to the same to show court the history
Yes.
of what's happened here, and as I say, to accept it was a benevolent purpose, but whilst my learned friend to accept what is said there was a considered decision to remove it. I think that must be common ground in relation to other welfare benefits, and it remained in the tax credit system in the circumstances that have been described.
In a sense,
Of course, it's a benevolent provision. In the sense
Yes.
that it expands entitlement in a way that if that regulation wasn't there, would not be the case. And it's a way in which tax credits can be said to have been more generous to new refugees than the universal credit system replacing it.
yes.
The question then becomes, are the legislative provisions effective to replace tax credits with universal credits for all purposes, because they require it to be possible to make a claim for tax credits, and if it's not possible to make a claim for tax credits, you only get your universal credit, or does the court see the necessity of reading a way round that effectively in circumstances where the substantive challenge, the fairness, the alleged discriminatory aspect of this provision has not been pursued? So, my lords, I need to summarise on the statutory scheme. I say this isn't a question of not giving effect to a deeming provision in Regulation 3. It's just that there is nothing for Regulation 3 to operate on in the absence of a claim that can be made. But it's not, as has been described, a lacuna or an oversight. It's simply something that wasn't necessary because of the way that the statutory scheme is structured. And to summarise my answer to my Lord Justice Singh's point, it's not a question of taking away rights without using express words to do so. The statutory scheme is entirely clear that universal credit replaces tax credits, and that universal credit doesn't include any form of backdating provision.
Well, it's quite clear for the future. It's ambitious, I suggest, to say that it's quite clear that it was intended to stop backdating of claims by means of regulations 3.5 and 3.6 of the 2003 regulations. That may be where one gets to, but
well, I say it's I absolutely accept it's not clear on the first reading. That's, I think, in fairness to my clients, not unusual in social security legislation, and in part at least a function of the complexity of what's having to be done. But I do say that on analysis, the only way that in which it makes sense is that claim in Article 7.1 must mean claim as defined in the regulations that exist for the purpose of, amongst other things, defining how a claim is to be made. And that's why those are the relevant regulations for the purpose of that provision. The alternative argument is that there is some other way of making a claim for the purposes of Regulation 3.5, which is not prescribed in any way, that it could simply be any, but, well, that's, in my submission, inconsistent with the structure of the system, which is that claim is the claim that the new refugee or newly recognised refugee makes for their ongoing benefits. And there's no power under Section 42 to make regulations about how claims are made. There is a power to modify other provisions of Part 1 of the Act, and there's no modification in relation to the Section 4 and Regulation 5 requirements to make a claim. So those still apply. My lords, if I might then go on and deal with Adnan.
yes.
That's, first of all, decision of the Outer House at tab 13 of the main authorities bundle. It's in the second volume. my Lords, my Lady will be aware that Adnan was Mr. and Mrs. Adnan were in effectively the same position as Mr. DK and brought the same claim, albeit only on what was ground one of my own friend's case below, in Scotland as a judicial review to the outer house of the Court of Session. And that case was heard and handed down on the 15th of June 2021. The court may have noticed that the hearing before Mr. Justice Bourne was on the 16th of June 2021. So although we were tight up against the hearing when we received the decision of the inner house last week, it wasn't quite the same as the position in which we found ourselves in June of this year. Well, the decision of the outer house
We can go to paragraph 16, can't we?
begins at paragraph 16. Really, up to that point, it simply sets out the competing arguments and statutory provisions. And then begins at paragraph 16 with Lord Tyre's opinion that the petitioner's, Mr. and Mrs. Adnan's argument is to be preferred because, first reason, the critical point of dispute is whether the terms of Articles 7, 1 and 8 of the Commencement No. 23 order entirely exclude the possibility of a claim being made under Regulation 3.5a of the 2003 regulations, to which the backdating in Regulation 3.6 is applicable. And as I say, what that doesn't engage with is the proposition that one can't make a claim under Regulation 3.5. Regulation 3.5 operates if a claim is made. He then goes on to say they don't do so expressly, and I say it's because with respect that there's nothing expressed to be said there, and says that the argument presented on behalf of HMRC depends upon the distinction being drawn between entitlement to tax credit on the one hand and the possibility, as he puts it in inverted commas, of making a claim for tax credit on the other. And as I've already submitted to you, that is not a distinction that HMRC have dreamt up. It's a distinction that is expressly drawn on the face of the legislation, that entitlement to tax credit depends on the making of a claim for it.
Well, Lord Tyre's answer to that for Laurel is paragraph 19, isn't it?
Well, so we'll come on to that, but that's where he talks about the deeming provision. As I say, the deeming provision has nothing to deem if there is no claim under Regulation 3.5. And I feel like something of a stuck record on this point, and I apologise.
Right.
But I will come on to deal with.
If there's your point is that if there is no claim, or can be no claim, you can't deem the claim to have been made at any particular point.
Yes, Regulation 3.5 says if a refugee claims, and as if a refugee can't claim,
Yes.
then it simply doesn't operate.
To which one answer may be, as I've been suggesting, at least for the sake of argument, because I have no firm view on this at all, that if one looks at matters of substance rather than form and asks what was the rationale for the deeming provision, might it be said that the reason why the deeming provision is there at all is because it was trying to recognise that a state of affairs had always been the case. It's just that it had now received an official state decision recognising it.
And well, that's really not. I don't dispute that. That more generous provision in relation to backdating was present in tax credits, and it's not present in universal credit. And if one can't claim tax credits, one can't then claim the benefit of the more generous provisions of tax credits. That's
I understand.
it really is in my submission, almost as simple as that.
Yes.
Well, the other points in Adnan in the outer house. First of all, at paragraph 17, Lord Tyre says that refers to the wording of 7.8a being puzzling as referring to the date on which any action is taken, but does actually get to the point, the submission that I made a little while ago, that on the proper reading 7.8a is referring to action consisting of the making of a claim that meets the conditions in the 2002 regulations, with the consequence that a decision on it has to be made. And as he says, those conditions will include the formalities specified in Regulation 5, which is not disapplied by person in relation to 2003 regulations. He then says the starting point in practical terms in the present case is therefore that the petitioner's claim was made on the 14th of January 2020. As I say, that misses the point that a claim could not be made on the 14th of January 2020, and therefore fails to draw the consequence out of that submission that he accepted. Then at paragraph 18, turns to the provisions of the 2003 regulations, says it's common ground that the claim was submitted within 1 month of receiving notification of their reporting as refugees. Again, I say that depends on the ability to make a claim. He rejects the contention that Regulation 3.5 itself constitutes a barrier which must be overcome before the deeming provision in Regulation 3.6 is reached. My Lords, I don't make a submission that it's a barrier, it's simply the condition for the operation of the provision. If a refugee makes that claim, if the conditions are met, then Regulation 3.6 can operate, but if a refugee can't make that claim, they can't operate.
It was illegal.
The claim cannot be made. That's the wording of the of Article 7.1. And then paragraph 19, coming back to the point made by my Lord Justice Singh, but Lord Tyre's conclusion there is that he finds no reason to treat the deeming provision as being overridden by Article 7. I said, well, that's, on analysis, that's not what's happening. The deeming provision is not being overridden. There simply is. It simply isn't engaged.
Yes.
And paragraph 20, I've already dealt with the point about it being a lacuna. So it's not a lacuna, it's simply only dealing with, in Article 7, the operative regulations that determine the conditions for making a claim, what action it is that requires a decision on the claim to be made.
Just a slight ancillary question, it may not matter, but Lord Tyre refers a number of times there to Parliament. Is that strictly accurate? Because the legislation isn't the product of Parliament.
Well, there is an order that was laid, so it could have been contested.
Oh, I see. Yes.
Parliament. So it's not primary legislation that was debated.
No.
It's the Section 150 gives the Secretary of State power to make the transitional provisions by order.
Yes.
I just want to double check I'm not giving bad
Subject
information.
Any negative prayer that it takes effect unless it's prayed against within 40 days or
Yes, 42 days, I think.
Yes. It may not matter, but certainly speaking for myself, I've always thought it's quite important to distinguish between the executive and Parliament. Sometimes the executive thinks it is Parliament, but it's not.
Well, it's precisely what makes the question of intention in this context so problematic, because whilst one obviously is looking for parliamentary intention in statutory instrument made under an Act of Parliament, most members of Parliament will be blissfully unaware, frankly, that it was laid.
Well, yes, and it would have been perfectly open to the draftsman of Order 23, to make it clear on the face of the regulations, we're fed up with this scheme under which successful asylum seekers have their claims backdated. Therefore, from now on, there will be no backdating of asylum seekers' claims. That causes injustice. Well, too bad. That now, if the regulations had contained something which flagged that up, it would have been perfectly open. It's within the scope of regulations, and if there wasn't a successful negative resolution motion moved in Parliament against it, then it would have come into effect and nobody could have complained. That isn't what happened here. So we have to assume that the same result has been achieved, even though it takes helpful. One needs a guide such as yourself to lead one through the thicket of provisions.
And well, I suppose the counter submission to that is that on the face of the primary legislation, it could not be clearer. And there's nothing to indicate that there was ever any intention to have a partial rollout in relation to individuals. So the provisions of the universal credit provisions are applied to a person who can claim universal credit. And it's the debate that's being had is because of the way that was expressed in the regulation, in Article 7 of the order. But there's nothing anywhere in my submission to indicate there was ever any intention to partially apply the provisions of universal credit, but to keep some other part of it alive. That would be a much more complex implementing provision, even more complex implementing provision. And of course it is relevant in my submission to keep clearly in mind that this is, that the complexity here was about the staging of the rollout and keeping that manageable. So that it went, as Mr. Naeem describes, firstly there were gateway conditions, so until 2015 all refugees would have been claiming tax credit, because unless one was a British citizen, universal credit was not rolled out beyond British citizens, even in the areas.
Yes.
And it's only after that that within particular areas it's rolled out to everyone.
The point is, you say that what the intention is clear from the primary legislation, is that once you're caught by the UC regulations, once it's rolled out to you, then you take it warts and all.
Yes.
There's no backdating of any sort of claim for universal credit. You don't retain any rights to legacy benefits at the same time as being able to claim universal credit. It's a clear-cut line. And therefore you can't have this kind of hybrid whereby you qualify for universal credit, but at the same time you can claim a legacy benefit. That's the position.
Yes. Yes.
And if that causes a perceived unfairness, well, it swings and roundabouts. You may be better off under some provisions and worse off under others.
Well, they did precisely that, and also that the substantive position was explored at first instance in the human rights claim.
Yeah.
And it hasn't been pursued.
Yes, it's obvious that once universal credit is rolled out and reaches you, whether it's geographical basis or a citizenship basis or whatever it is, you can't claim the legacy benefits such as child tax credit for the future. Of course not. But is it so clear that the position for past years before the change is taken away?
Well, I said it is,
Yeah.
because entitlement depends on a claim,
Yeah.
and you are prevented from making a claim.
Yeah.
And therefore you have never had any entitlement because you have not been able to make a claim.
That puts it very succinctly. Right, is there any ground we have yet to cover?
Well, only the inner house decision in Adnan.
Oh yes, right.
And my lords and my lady will no doubt be somewhat relieved to hear that it doesn't really traverse any of the ground that we've covered so far. It gives some discrete reasons for, as it's put, preferring the case put against them. It's tab 1 of the supplementary bundle of authorities. It's a total of 7 pages, including the one that has the final line on.
How common such a short judgment is in Scotland, but it would be remarkably short in this court, where, in the opinion of some of us, many judgments are too long. No one could say this one is too long.
Well, Lord, my submission would be that there's a balance to be struck.
Yes.
Somewhere between this and too long.
Yes.
Would be appropriate.
Yes.
For a judgment. Well, it's really the operative part after setting out the main provisions. Begins at paragraph 12 on page 5.
Yes.
And it begins with the proposition that the 2003 regulations and 2015 order appear to supply different answers to the central issue, because Regulation 3 allows the petitioners to claim tax credit. Article 7 does not. I say with that, that's a point that I have already traversed at some length.
Yes.
And then HMRC's submission is summarised at paragraph 13 as being that once individuals are entitled to claim universal credit, they cannot claim backdated child tax credit, and that's accurate so far as it goes. And it's described as attractively simple, but there are 3 reasons given in the next 3 paragraphs described as major difficulties with that submission. The first, paragraph 14, is it said to treat Regulation 3 as being of no force or effect. And again, well, that's a point that I've covered to some extent, but my submission, of course, is simply that they're not treated as being of no force or effect, they're treated as not being operative, because a claim can't be made in this situation. Secondly, the Inner House refers to the amendments that have been made to Regulation 3.
I'm sorry to take you back to the first of those reasons. Forgive me. I think the point that's being made is that it didn't expressly revoke or appeal. In fact, it doesn't refer to the 2003 regulations at all, whereas it materially amended the 2002 regulations. Does the submission? I don't want to put words in your mouth. Please do respond to this if this isn't right. Is the point being made that effectively HMRC's argument was that although there express repeal of Regulation 3, there was implied repeal of it.
I don't understand that argument to have been run.
Right.
I did see at one stage an argument, a written argument in Adnan, and I don't recall there was any argument about implied repeal.
But can I put it to you that that is what your submission amounts to? That it could expressly have said, and then everyone would know clearly what's happened to this deeming provision from the past. It's no longer operative. You say your submission is not that it doesn't have force or effect, but that it's no longer operative. Well, somebody might say
the facts that make it operative no longer arise.
Yes, I see.
And that might equally be said to apply to many parts of the 2002 regulations. What hasn't been done is to repeal en masse, particularly in circumstances, and this overlaps with the next paragraph about amendments, where some parts of Regulation 3 continue to have meaning in the current world.
It effectively makes that particular provision a redundant provision.
Yes.
It's not being formally repealed in the sense that it can no longer be relied upon. In practical terms, there is no possibility of it being relied upon.
Yes.
It becomes redundant.
Yes. Redundant is exactly the word I was groping for.
Of course, that's right, but like many propositions of law, it is right if you actually write on your fundamental submission. What Lord Woolman, I think, is saying is, well, hang on, there is on the face of it a piece of legislation which is still extant, and we've got to do something with it, unless it's been repealed. What's it still doing there?
I would say it's part of the previous system, which, for reasons that have been touched on, has not been fully repealed. Parts of it need to still exist. It's not difficult in my submission to envisage me being here trying to defend an even more complex attempt at repealing some parts and not other parts, and leaving scope for argument as to the effect of those more complex attempts at leaving part of the system in place.
Yes, I do understand that, can I put it this way? Would you say that the reasoning at paragraph 14 is absurd? Because on the face of it, to me, it doesn't sound absurd. It may be wrong, but I can see why Lord Woolman is making the point he is.
But absurd would probably be putting it too high, but don't say that it affects the force of the arguments.
Okay.
It is entirely
Clearly wrong, maybe. You may not be allowed to describe a judicial decision as absurd, but you say it's so clearly wrong that we shouldn't follow.
But I suppose the real difficulty with it, in my submission, would be the proposition that Regulation 3 conferred a contingent right on asylum seekers, which is then being taken away. And my submission is there is no contingent right, entitlement to a tax credit that has not been claimed. So what it did was to provide certain consequences if a claim was made, predicated on the ability to make that claim.
Well, the point would have more force if the human rights point was right. If the nature of the what you get under Regulation 3 was some kind of entrenched right to make to claim the money or right to the money, subject to the formalities of making a claim for it, that was the correct characterisation, then you can see where he's coming from. You can't take away that sort of right without repealing the legislation that confers it. If there is no right, either actual or contingent, then the argument becomes less forceful.
Yes.
But the point about taking away vested rights, if that's what they are, Mr. Cox doesn't need the Human Rights Act for that. That's been a presumption in our law for years. And speaking for myself, I don't think the Human Rights Act ground added very much to this question. If it's a quite old-fashioned statutory interpretation case.
Well, Jess, I think I understood my lady's point as being that there would be more force if what was happened was also discriminatory, I suppose, or was.
Well, if it was treated as a vested right,
Yes.
your point is it isn't.
There isn't
Yes.
right.
That
Yes, but that's
I was
the
rather
short point. Yes.
clumsily trying to articulate it.
Yes. I may have used an inapt phrase. It's not really a vested right, but what Lord Wilman is saying, right or wrong, is that there is a contingent right. In other words, it's really what I've been trying to suggest is the difference between substance and form. That in form, refugee status is only recognised at a later date, but the underlying rationale for backdating, the deeming provision rationale, may be that one is trying to recognise what was always the state of affairs as a matter of substance. I'm not suggesting that it was a vested legal right, and that's what I think Lord Wilman is trying to capture with his phrase contingent right. Now you may say even that is wrong, and I understand that, but as my Lord said, really, when we started this hearing, we're faced with the fact that we're not dealing with this issue of law with a blank slate. We're dealing with it against the background of a decision of the Inner House on the same legislation, which has UK, is it UK-wide application? Yeah. And so it's clear, I think everyone recognises it'd be highly undesirable for us to reach a decision which will bind tribunals and courts below us in this jurisdiction, which is fundamentally inconsistent with what they've said. Legislation means north of the border. Now there are circumstances in which we can do that, and I think the test for that is common ground. But I'm just speaking for myself only. I'm just wondering whether this really is so clearly wrong that we should not follow it.
I think my Lord's point, if I've understood it, is that this is really a compressed version of the debate that we've been having.
Yes.
And that I think I'd have to accept that's a possible reading of the judgment of the Inner House, albeit it doesn't explore the substance of the issues in a way that enables one to really grapple with the competing arguments on each side. But in any event, you have, I think, my submissions on there not being a right to be removed, and that the difference between universal credit and tax credits being apparent on the face of the legislation. The second point that the Inner House has made difficulty with HMRC's position are the amendments to the 2003 regulations, or to Regulation 3, that have occurred since Article 7 came into force in 2015. The first two of those, on the 10th of March 2015 and the 20th of July 2018, as I read that paragraph, Lord Woolman accepts HMRC's submission that there were still remained a small pool of individuals entitled to claim tax credits until the 1st of February 2019, so until full rollout had been achieved effectively. But then says that only provides an explanation for amendments made before this date. And I've explained at paragraph 4.2 of my supplementary skeleton argument the the second sentence of that paragraph deals with the 2015 and 2018 amendments. But in my submission, they, as recognised by Lord Alden, don't add a great deal because there would still have been areas in which universal credit was not fully rolled out, in which there may have been people making claims on which Regulation 3.5 would bite. The 2020 and 2021 amendments, as I've explained in the first part of paragraph 4.2 of my supplementary skeleton argument, are those that I foreshadowed when I showed the court Regulation 3, Case 5 in Regulation 3.1, which relates to the position of third country nationals taking advantage of EU treaties. And the amendments, so as I submitted, there may be people in that category who are not yet subject to managed migration, so there's an ongoing effect of that provision. And that's been amended, tidied up post-EU exit to reflect a current proper terminology for their status, and requirements for their status. So as I say, that reason doesn't add anything, doesn't show that HMRC has been operating on the basis that this part of Regulation 3 can still operate since 2019. It simply hasn't. The amendments were made to a separate part of the regulation.
I'm sorry, I think I follow what's going on there, but just help me with that. Is that, in a sense, is that a kind of transitional provision? Is it recognising that if you suddenly pulled up the drawbridge on the date of EU exit, that there would be some people who would be adversely affected? Is that what lies beneath those amendments?
Well, my understanding is that the previous drafting referred to get the regulation in front of me, but the previous drafting reflected the position when the UK was a member of the EU.
Yes.
This is page 100, isn't it, of the main authorities bundle.
So which page is it?
It's page, 100, behind tab 4 in the main authorities bundle. Oh no, sorry, 99 in fact, I apologise.
Yes, case 5. Yes.
So the two amendments at issue are the little 4 at the end there. Those words were substituted with effect from the 1st of January 2021. And the little 3, which was a replacement of the entire paragraph, which was then amended by the little 4s.
I'm sorry, I'm not following where you are. It's my fault.
No, it's my fault.
Case 5.
So case 5.
Yeah.
Well, we'll see firstly a square bracket at the start.
Yes.
And then one at the very, very end, just above the subparagraph 2.
Yes.
And that indicates, with the little 3 there, that the whole of that case 5.
Oh, you mean footnote 3?
Yes.
Yeah, I've got it.
Sorry, I say little.
Yeah.
So footnote 3 is a reference to the 2019 EU exit regulations.
Yes.
Came into effect on the 31st, with effect from 31st December 2020. That was a full substitution of case 5. And then the footnote 4, which applies to a person who is lawfully working in the United Kingdom and also subparagraphs A and B, is the amendment with effect from the 1st of January 2021, which is the further set of EU exit regulations 2020 this time, and those both appear in the supplementary bundle at tabs 6 and 7, so pages 67, first of all. 67, you see the wholesale replacement of case 5 with a person who's lawfully working in the United Kingdom, etc. And then on page 68, the next tab, the 2020 regulations, which came into force on the 1st of January 2021, which make further changes.
I suppose what I'm getting at, and I don't want to interrupt your submissions at all, but it may save time. What I'm getting at is that clearly somebody seems to have thought it was important, despite the fact that we were leaving the EU, to cater for this category of people in some way. And I may be wrong, but I think what Lord Woolman is saying is, well, if that's right, that there were some people where it may have been thought that it would be wrong just to draw up the drawbridge completely, and they had to be expressly catered for, then similarly it might be said that people in these claimants' position would simply be left high and dry, because there was the deeming provision in the past, which did have retrospective effect. And if you wanted to remove that contingent right, then you would have said so. I think that may be what he's getting at, but I may be wrong.
Well, these, of course, are people who they're not being permitted to make a claim.
Right.
They're, as I explained, not excluded from entitlement.
Well, they've already made a claim.
They've already made a claim.
They've already made a claim, and that claim would continue under the legacy system to be rolled out on an annual basis as a result of all the regulations we've looked at, until they get migrated across to universal credit, which you say would be done manually.
But
Or potentially be done manually rather than postcode. Yeah.
there's a managed migration pilot, and
Yeah.
the details of that, I'm afraid I can't assist.
So
you
they're
with
a different species, because they're not people who would be making backdated claims. They're in the system, or they've kicked themselves into the system before Brexit, and this is really designed to stop them falling through the cracks. So they haven't yet been moved over to universal credit. It's designed to stop them losing the benefit to which they've already made a claim.
Yes.
Yeah.
So the fundamental point you're making is they are people who have already made a claim.
Yes.
Yeah, whereas the present claimants and the ones in Scotland were people who hadn't yet made a claim.
Yes.
Yeah.
Yes. But insofar as the reasoning is that the reasoning of the inner house is that HMRC has failed to extend the regulation. I say those parts aren't redundant
Yes.
for that reason. And then thirdly and finally, in terms of what is said to be major difficulties with HMRC's case, it said at paragraph 16 to yield an arbitrary result, because the ability to claim backdated child tax credit would turn in a random event as to whether universal credit had been rolled out in a particular area. Well, of course, my submission is that's simply a function of the rollout. That if the rollout is being done by postcode, as it is, insofar as there are less generous features of the new system, it will, once one chooses to use the term postcode lottery, that will apply to all features of the new system. Then open page on page 6, paragraph 17, it said that the words "that date" in Article 7.1 refer to the deemed date of the asylum claim in terms of Regulation 3.6. I say that can't be right when one looks at the structure of Article 7 and the specific reference to the 2002 regulations as being the relevant regulations under which action is taken that requires a decision to be made. It simply doesn't syntactically make sense to say that's a reference to Regulation 3.6. And insofar as he says at the end of that paragraph, it avoids an absurd result. Of course, my summation is that for all the reasons already canvassed, it's very much not an absurd result, it's simply a clean switch from one system to the other. Paragraph 18 states a conclusion that Article 7.8a doesn't exist because the petitioners have complied with Regulation 5 of the 2002 regulations, and so of course that they weren't permitted to comply with those regulations or to make that claim. And then finally, in relation to paragraph 19 and the broader contention, I don't make the submission that Parliament could not have intended to allow refugees to continue to benefit from backdated claims whilst excluding such claims from the majority. But insofar as the submission is made that the position that I advance is absurd, or that can't have been parliamentary intention, I do say, well, you have the evidence of Mr. Naeem, which, without getting into the specifics of it, set out in some detail to justify that as having been the intention behind the relevant provisions.
Do you have a submission to make about the final sentence of paragraph 19?
Well, that goes back to this question of it being the 2002 regulations that define when a claim, how a claim is made, and therefore when a decision is required. Because as I said, Regulation 3.6 and not a specific category of type of claim. There's no provision that says, well, 2002 regulations apply under Section 4 for the making of claims, but you can also make a claim in this way and engage Regulation 3 of the 2003 regulations. It's the 2002 regulations that govern the making of claims, and that's why they had to be dealt with there. That's why they were the relevant regulations for the purpose of identifying the date on which that regulation applies, that article applies. The last paragraph of the last substantive paragraph refers to the decision of Mr. Justice Bourne, the decision that's under appeal to you. As Lord Warner notes there, and as I've dealt with in my skirting argument, Mr. Justice Bourne did express considerable doubts about the proposition which he felt constrained to accept on the basis of the Outer House decision. I'd invite this court to share those doubts. As I said at the outset, I don't formally concede that this appeal can't be allowed, but I accept that if my clients are to prevail on the interpretation of this legislation, it will have to go to the Supreme Court in any event because of the position in Scotland. In those circumstances, therefore, I'd ask this court to give those submissions very careful consideration.
And in Scotland, no longer appeal as of right in Scotland.
No, my lord, it's I did check this.
Yes.
It talked to me last week. There's 28 days after the decision of the Inner House to make the application to the Inner House. So it's somewhat different, the situation in this court, where any application normally made on the hand down of the judgment.
Yes.
So they have 28 days, and then it's only when the inner house, if and when the inner house refuse permission, that there's then a further 28 days.
They then apply to the Supreme Court. When I was a lad, I think civil appeals in Scotland from the inner house to the House of Lords were as of right, but
those were the days.
no longer.
That may have made my position today somewhat easier.
Any questions? Thank you very much, Ms. Ward. You've been very patient with us. We'll rise and discuss where we go from here.
Rise.
I don't wear a watch, so I had no idea what the time was.
It's just coming up to half. I've just gone half 12.
No, I must have a bus, it's not around. Yeah.
All right.
Mr. Cox, we need not call on you to reach our decision, which is that for reasons which we'll give in writing in due course, the Revenue's appeal will be dismissed. We haven't decided to what extent we will say anything at all about the merits of the decision of the Inner House. In reaching that decision, we will have careful regard to what you and Mr. Spencer have said in your skeleton argument, as well as obviously to the judgment below and the judgments of Lord Tyre and the Inner House in Scotland. Is there anything which you feel compelled to add at this stage? We're not encouraging you, but if there's anything you did want to say, which particularly if it wasn't contained in the skeleton argument, obviously we would allow you to do so. But you have one.
Well, I'm grateful. Might I just make 3 points? 2, I think, by way of highlight. The first one is that the important part of the Revenue's case below was that it would be a consequence of the DK's argument, if successful, that DK would be entitled to tax credits and universal credits for the same weeks. That was rejected by the judge. And so a lot of the comments that you see from Mr. Name are in that context, that there would be parallel entitlements that would go forwards. And that submission is contained in my learned friend's skeleton argument at paragraph 37 of page 88 of the core binding below. And that was rejected at paragraph 39 of the judge's judgment, it's Justice Baldwin's, at 46 below.
Sorry, paragraph 46.
Paragraph 39 of the judge's judgment, page 46.
I'm sorry.
Right.
And so this is a case about not overlapping entitlements, but the simultaneous operation of a scheme looking forwards and a scheme that is entirely dealing with a past period. And so my second point to you is that my learned friend did not take you to any indication that it was Parliament or the Secretary of State's intention to interfere with what I say that was correctly described by the Inner House as a contingent right. In substance, for the reasons canvassed in argument by my Lord Justice Singh. And those are matters, would be important to a human rights argument, but they're also important for this court's interpretation of statutory provisions, because the legislator ought to be understood to less readily take away certain things or certain possibilities than other matters. And there is a difference between saying you will now get universal credit, not tax credits going forwards, and saying you will now get universal credit and therefore you may not have tax credits for this past period. My learned friend's reliance on the legislative provisions that did not make provision for backdated benefits for refugees in the universal credit scheme, I say is in my favour, because I say that shows that Parliament and the Secretary of State, or rather in this case HMRC, wanted to leave in place a scheme for backdated benefits.
Or at least you would say, assumed that the position in the past was not being touched, and here we're legislating for the future. Is that how you put it?
Well, 2 points, that they certainly did leave it in place. It's still there. And it's accepted by my learned friend that some people could still have claimed it if they were in the right postcode areas. So at the same moment that Parliament was saying refugees won't get backdated universal credits, Parliament was leaving in place, and HMRC chose to leave in place because they could have revoked it. They chose to leave in place that mechanism for those refugees to claim backdated tax credits. And I say that legislative scheme evinces an intention that refugees should go on getting tax credits. Not that there should be some kind of implication that in language which is unclear, that the intention is whenever possible to take those rights away. That's not the implication of leaving them in place. It's the other way around. And lastly, textually, if I could just ask your lordships, first of all, to turn up Regulation 3 of the 2003 regulations, which is at page 100 of the authorities bundle. And if your lordships and my lady have the two authorities bundles in two different bundles, would you also turn up page 284 in the second volume, which is the other of the two provisions that are most central to this case, the text of Regulation 7.8.
They're both in the judge's
If they're both in the same, I'm sorry.
Well, they're both in the judge's judgment.
But they are also.
Those are the two you want.
Yes. And I'm going to, if I may, and I appreciate this can sometimes be annoying, say what could have been put in the provisions to make it clear, but by way of illustrating what I say is the correct interpretation. Regulation 3.6 says, Regulation 3.6 applies where a person claims tax credit. That's Regulation 3.5. And then Regulation 3.6 says, he shall be treated as having claimed tax credits. Then it deems the dates rather than on those dates.
Yes.
It doesn't tell us for what purposes. It doesn't say, and it could have been amended by the commencement order, for the purposes of the commencement order number 23. If it had said that, or equivalent words, then we would know that that's what this is talking about. But the other way of reading it is that it means, shall be treated as having claimed tax credits for all purposes. Now, my learned friend would have you read it as, but not for the purposes of the commencement order number 23. But it doesn't say that.
Well, you don't even get that because it's not a claim.
That's right.
You can't be, because he in 3.6 means that person in 3.5b.
Yes, that's right.
And if Miss Ward's argument is right, then that person can't claim tax credit because it's become illegal by
Yes.
side wind.
I see that. But if I could ask your lordships then to look at Regulation 7.8.
Right.
And 7.8, sorry, Article 7.8. It explains what a claim means for the purposes of Article 7.
Yes.
And it tells us two things about that. It tells us that the claim is made on the date on which he or she takes any action which results in a decision on a claim being required under the relevant regulations. And then it says, it is irrelevant that the effect of any provision of the relevant regulations is that for the purpose of those regulations the claim is made, or treated as made on a date that is earlier than the date on which that action is taken. Now, again, we wouldn't be here if that had said it is irrelevant that the effect of any provision of the relevant regulations or the 2003 tax credits immigration regulations. Now, my learned friend submission is essentially that this is, or I say has to be, that this is for abundant caution, that it's also silently irrelevant that the effect of a provision of the 2000 regulations is that a claim is treated as made on a date that is earlier than the date on which that action is taken. And that is the implied repeal or the implied disapplication or redundancy of the 2003 regulations that my learned friend asks you to accept. And I say that the author of the 2015 regulations is to be understood to know of the existence of the 2003 regulations, that they remain in force. And there are two ways to read this, that is either the author intended to catch 2003 regulations by precluding a claim under the 2002 regulations, or that the absence of reference to the 2003 regulations was so that the deeming provision in Regulation 3.6 of those would, to use the language of Article 7.8, have the effect that the claim is treated as made on a date that is earlier than the date on which that action is taken. And given the exceptional character of the contingent right here at stake, which is for a period of entitlement before there could have even been a claim for universal credit, before universal credit even existed, the implication, the correct implication of the language that the draftsperson of the 2015 order has chosen is that it was not intended to impact that contingent right. That is the construction solution to the absence of any intention evinced to preclude a claim for that historical period beyond the language of Article 7.1.
Is this what Lord Woolman meant when he referred to meshing of the two provisions?
Yes. And to turn to the Scottish Court's judgments, when Lord Woolman says at Article 16, a refugee's ability to claim backdated child tax credit would turn on a random event. In my submission, that's right. It's one thing to say, you will move over to the new form of means-tested benefits at different times, depending on where you live. And yes, some of you may be better off and some of you may be worse off. But it is a different quality when you say, and also, you therefore can't claim this old benefit that we had for refugees for a period before this new benefit even existed. That is arbitrary. And that is the reconciliation in my submission at paragraph 17 of the judgment. And also why Lord Woolman has referred at paragraph 19 to the difficulty of explaining why Article 7.8b expressly excluded the backdating of other tax credits. And it's accepted or it's not asserted, that Parliament intended, or rather that Parliament did not intend to allow refugees to continue to benefit from backdated claims. The contention is that was the intention of the Secretary of State for Work and Pensions by making this commencement order for universal credit, that they would, in substance, repeal Section 140 of the Act and revoke the regulations for this class of people by the mechanism of denying the possibility of a claim. Now, in my submission, that doesn't find any root in the doesn't find any clear intention route in the Act. I'm not saying it's an impermissible mechanism, but it's a permissible mechanism which should only be allowed to operate insofar as it's clear on the face that it intended to take away those possibilities. Shouldn't be allowed to go further than that as a mere commencement order of the Welfare Reform Act, which didn't repeal these provisions.
So to be clear, Mr. Cox, that I've understood a submission you made a few minutes ago about the reach of the deeming provision. Is it your submission that that is a deeming provision which, on its face, has, as a matter of textual interpretation, has effect for all purposes? In other words, as a matter, it's saying this is deemed to be the position on the date point as a matter of law.
Yes.
It's not confined for the purposes of these regulations. It's not saying that. It's saying for the purpose of the general law,
yes,
this is the deemed state of affairs.
Yes.
And therefore, it helps you to understand what date means in Article 7 of the Order.
Yes.
Which is what Lord Woolman, I think, is really saying at paragraph 17, that that's how you can reconcile the two provisions.
Yes. My learned friend, and I accept that her construction is an arguable one, textually. She says, well, normally the 2002 regulations would apply, and then the 2003 regulations would bite on the 2002 claim. But Article 7 comes in and stops you from getting to the 2002 regulations. They run in a line. And I say, well, but the draftsmen, when they wrote Article 7, also knew that 2003 regulations modified the meaning of claim and in a circle. And so he's looking at that. And the question for you is, did the draftsperson of the regulations intend to shut out access to that circle? Or did they see it as a different category of case because it's only backdating?
But the 2003 regulations didn't change the way in which you make a claim if you fall within that category of person. So you've still got to make the claim in the way that's envisaged in the 2002 regulations. And there's nothing in the 2003 regulations that gives you any other way of making a claim.
My lady, that is correct.
And that's the problem I have with your analysis.
But my lady, that's also true of the provisions referred to in Article 7.8b. They also required a claim to be made in order for a claim to be treated as made on a date that's earlier. And yet they needed to be disapplied. And that might have been purely out of abundant caution. One possible interpretation is that purely out of abundant caution because the draft person had heard the way that my lady's just expressed it and actually knew they didn't need to do that. The alternative interpretation is that the draft person is looking at these very complicated schemes in which a claim is not always a claim and the date of a claim is not always what factually otherwise might be the date of the claim. And saying, I'm going to make those irrelevant, but I'm not going to make the 2003 regulations irrelevant, because that's a different kettle of fish. And at one level, it is if I might say, a policy decision. And I say that the policy issues here are heavily weighted in our favour, because what the Secretary of State seeks to do is to take away a contingent benefit for no seemingly strong policy reason other than saving funds. So this is not a complexity of overlapping benefits. It's not a question of the benefits being needed to be assessed at the same time. It's not a question of tax credits having been abolished. They haven't been abolished. There are still staff out there dealing with tax credits. There's no policy rationale for doing is the policy rationale is we're trying to get rid of these backdated benefits of refugees. That's what we're told is the policy rationale. But that isn't Parliament's rationale. Parliament hasn't got rid of backdated benefits for refugees.
Or the
I'm not sure it gets any better.
Minister. Yes.
I
Right.
said I'd only I said I'd be sure.
Thank you. Thank you both very much.
May I say just one very, very brief point, which
Yes.
is, it was my mistake about overlapping the defendant and skeleton argument. I accepted that at the hearing. So when it said the judge rejected, I accepted the judge had to reject that, but I wouldn't want it to be attributed to Mr. Naeem. That was the only point in response.
Well, that's very chivalrous of you. I'm sure we won't be criticising Mr. Naeem. Thank you both very much. We will give our reasons in due course. Does anybody have any preference as to whether an order is drawn up now or postponed until we've given reasons? Presumably, Ms. Ward, there can't be any dispute about costs. So the order would simply be that the appeal is dismissed with cost.
It would simply be a question of when the time for applying to the Supreme Court started to run, and
you might want us not to have
would
an order
ask
drawn
that
up.
HMRC have the benefit of whatever this court sees fit to say before making that decision and certainly making that application.
Right, we will not have an order drawn up until we hand down our decision, which we will do in the usual way, which you all know so well. Right, thank you very much for your assistance.
Court